Hello friends, in the series on income tax cases, today we will discuss a very important issue which was before the Honorable Guwahati High Court, and the issue was that if the CIT appeal and the tribunal gave a finding and gave relief to the assessee on the basis that there was no incriminating material with the assessing officer in case of unabated assessment. So whether there was incriminating material or not with the assessing officer for making the addition is a substantial question of law. This issue has been taken up by Honorable Guwahati High Court in the case of Principal Commissioner of Income Tax versus Rohit Kumar Jain, and this case is reported in 484 ITR at page number 109. The date of the judgment is 13th March 2025. In the present case, the case relates to the assessment year 14-15. The assessee has filed his income tax return under section 139 subsection 1, and the assessee has shown his income at a figure of 2,30,000 rupees. There was search on the assessee. The notice under section 153A was issued to the assessee. The proceedings were initiated against the assessee, and during the assessment proceedings, the learned assessing officer made the addition and pegged the figure of the assessee at a huge figure of 4 crore 25 lakh on the basis of retracted statement of the assessee. The assessee was pleading before the assessing officer that there is no incriminating material found in the search, so the addition cannot be made under section 153A in case of unabated assessment. But the AO made the addition when the matter was before the CIT appeal. The CIT appeal well appreciated the fact that in the present case, the case of the assessee is of unabated assessment, and the CIT appeal said that the completed assessment could not be opened in the absence of incriminating material in case of unabated assessment. The revenue took the matter to the tribunal, and the tribunal also gave a finding that in the present case, other than retracted statement, there was no other incriminating material with the assessing officer to justify the addition of rupees 4 crore 25 lakh. The revenue filed the appeal before the Honorable Supreme Court by saying that there is no doubt that under section 153A the assessment can be made only on the basis of incriminating material, and the contention of the department was that in the present case the addition was based on incriminating material, and the finding of CIT appeal and ITAT was perverse, meaning thereby that the revenue was admitting that 153A assessment can be completed only on the basis of incriminating material, but the only apprehension of the revenue was that the finding of the CIT appeal and ITAT was perverse as to the fact that there was no incriminating material. When the High Court heard the matter, the court was of the view that the CIT appeal and ITAT, after carefully scrutinizing the record, has held that the addition has been made only on the basis of the retracted statement, and the court said that in the present case, whether the material is incriminating or not has well established by the CIT appeal and the tribunal, so there is no substantial question of law. Friends, like in this case, the Guwahati High Court dismissed the appeal of the assessee. So in a number of cases, like when the additions are made on the allegation of the bogus purchases and the tribunal gave a finding that there is no bogus purchases, so even then the revenue files the appeal before the High Court very repeatedly without going into the merit of the case, because in that case also the question arises whether the purchase is bogus or not. Is a substantial question of law or not. So in these type of cases where the clear finding has been given by both the lower appellate authorities like CIT appeal and the tribunal, there arises no substantial question of law, and the appeal of the revenue should not be admitted. This can be the case with the assessee also, because first of all we have to see that whether there is substantial question of law or not. At the end of this video, once again I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus Rohit Karan Jain, and this case is reported in 484 ITR at page number 109, and the date of the judgment is 13th March 2025. Thank you, friends.